People think probate court is about paperwork, forms, signatures, quiet arguments over polished tables. They're wrong. Probate court is where families tell the truth by accident. My name is Evelyn Carter, and the day my family forced me into probate court wasn't the day I lost my husband. It was the day I learned what they had already decided I was worth. If you stay with me, you'll understand how one question, from a judge who barely looked up, took everything they planned and turned it against them. When my husband Daniel died, there was no screaming fight over his estate, not at first. There were hugs, soft voices, hands on my shoulders that lingered just long enough to feel rehearsed. Daniel had been careful his entire life, a systems engineer by training, a man who labeled cables and backed up hard drives twice. Of course he had a will. Of course it was detailed. The will left everything to me. The house, the investment accounts, the trust he'd built years earlier for future contingencies. My sister-in-law, Margaret, smiled when the attorney read it. Too quickly. Well, she said lightly, that simplifies things. It should have. But 3 days later, I received court papers. Petition to challenge the estate, filed by Margaret, co-signed by my nephew, Aaron. Their claim was simple. Daniel hadn't been well. I had influenced him. The transfers he made in the final weeks were irregular. They weren't asking for everything, just oversight, control, just enough to make sure I didn't have it. Probate court doesn't look dramatic. No raised voices, no pounding gavels, just fluorescent lights, and a judge who has already seen every version of human behavior you can imagine. Margaret's attorney spoke first. He described me as fragile, emotionally compromised. She was overwhelmed, he said, gesturing gently in my direction, and under those circumstances, decisions can be guided. I sat very still. They presented emails, Daniel reminding me to rest, Daniel telling me not to worry. They called it proof of dependency. Then they introduced the timeline, the transfers, the account changes, the trust amendments, all within a short window before his death, the attorney said. That raises concern. Concern. No one mentioned that Daniel had always done things in windows. I looked at Margaret. She wouldn't meet my eyes. When it was my turn, my lawyer stood. He didn't argue emotion. He didn't argue fairness. He argued process. Your Honor, he said, before we debate influence, may I ask a foundational question? The judge finally looked up. One, she said. Make it relevant. My lawyer nodded. Who requested the original probate filing? Margaret's attorney answered quickly. We did, Your Honor. No, my lawyer said calmly. I mean, who requested expedited review? There was a pause. The judge's pen stopped moving. Margaret shifted. Her attorney hesitated. The petitioners, he said. The judge leaned back slightly. And why, she asked, would beneficiaries who claim concern over undue influence push to accelerate asset control before discovery? Silence. That was the question. The one they hadn't rehearsed. My lawyer placed a single document on the evidence table. A printed audit log. Not emails, not opinions, metadata. Daniel Carter accessed his financial dashboard personally, my lawyer said, from his office terminal, two-factor authenticated, biometric confirmed. The judge raised an eyebrow. Dates? Every transaction they're disputing, my lawyer replied, initiated by him, confirmed by him, finalized without third-party input. Margaret's attorney objected. Too late. Then came the second document. A letter, dated 6 months earlier. Daniel's handwriting. It wasn't a will, it was a memorandum. If anyone challenges Evelyn's authority, it read, please note this. The changes were not reactionary. They were corrective. Corrective. The judge read it twice. Then she looked at Margaret. Miss Carter, she said evenly, were you aware of this memorandum? Margaret swallowed. No, she said. The judge nodded. That's unfortunate, she replied, because it explains motive. The judge dismissed the challenge, not with anger, with precision. She denied expedited control. She upheld the will. She sanctioned the petitioners for procedural abuse. But before she adjourned, she asked one final question. Mrs. Carter, she said, turning to me, did your husband ever express concern about family interference? I answered honestly, yes. The judge nodded once. Then this court recognizes the will not just as legal, she said, but intentional. Margaret didn't look at me as she gathered her papers. Aaron did. His expression wasn't anger, it was calculation. Probate court didn't give me closure, it gave me clarity. Grief makes people patient. Power reveals who isn't. They thought the money was the story. It wasn't. The story was control. And the moment the judge asked that question, everything they'd planned collapsed under its own timing. Because in probate court, facts don't shout. They wait. And when they speak, they don't ask for permission. If you've ever learned too late who was watching you wait, you already understand this story.